May I take, my lord? Mentioning before the Honorable Chief Justice only, the writ appeal against the cancellation of the site plot allotted to the appellant petitioner, judgment was by His Lordship Justice Krishna Dikshit. Lord, I could, the notice was ordered in the writ appeal and copies have been served on the other side. Continuously, my lord, I could not mention because of the bench combination. If my lords may direct special order for a constitution of a bench, my lord, my lord.
Division bench matter.
Division bench matter.
Which
the
division?
registrar has to place PDA.
Get it placed before on administrative side.
I can go the registrar.
With that new bench is to be constituted.
Please.
Justice Dikshit. Move
Yes,
the
this-
registrar judicial.
Because 2023 matter, continuously His Lordship was sitting in court hall 1, I could
Submit
not.
whatever you want to submit to the registrar judicial.
Please, my lord.
Yes, yes.
I may be permitted to make one mention for a 230 matter, my lords. The urgency is that the writ petition has been filed by the writ petitioner seeking installment of loan amount.
Division bench.
Yes, my lord, writ appeal it is filed today only. The urgency is that when the interim order was not complete, the bank has auctioned the property. The learned single judge has ordered to deposit the same amount before the registry of this honorable court. By the way of impugned final order, the learned single judge had directed the release of the amount.
Going to auction the property.
Yes, my lord.
When?
Auction. It was auctioned on 2022.
Then come Monday.
Monday.
My lord, serial number 5, my lord, I am for the respondent.
Serial number 5.
5, my lord. Petitioner counsel have to speak for short accommodation, my lord. I will oblige.
For the first respondent number 2 and 4.
You are for the?
Respondent number 2 and 4.
Nobody is for the petition.
My lord, in serial number 1, my lord,
Yes.
I am appearing for the petitioner, my lord. In
Yes.
this case, my lord, I need a short accommodation, my lord. I have to ready with the matter.
At the request of learned advocate Mr. Your Subramaniam PD Dattatra Hegde.
Subramanya PD, my lord, correct. Please.
Stand order. Will not give giving date. Adjourned. At the request of so and so for the read petitioners. Stand order to the next date. Only adjourned. Respondent. Keep back for the time. If somebody comes, well and good.
Next week, my lord.
Keep back. Pass over.
Next week, we will call. Short.
Next week you
We'll see.
hold.
Next week.
Still number 3.
Yes, I am appealing for the respondent, my lord. I
Petitioner.
pray for short accommodation in this case, my lord, because throat inspection. I'm taking
For
this.
petition.
I leave it to your lordships, my lords. I'm ready with the matter.
For petition.
Please, my lords.
What is it about?
Lords, the challenge, my lords, is it's
Inquiry. Yes.
the order of the disciplinary authority and the appellate authority, my lords. At annexure P and R. Annexure P starts at page 98, my lords, where the petitioner is imposed with a major penalty of dismissal from service. Lords, the only question before my lords is, my lords, during the course of inquiry, my lords, the petitioner had sought for legal assistance, my lords.
Sought for?
Legal assistance as a defense representative, rather, my lords, which opportunity was not granted to the petitioner. That is the only preliminary point. Now, whether the entire inquiry vitiates on the point that such defense opportunity was not given to him or not.
That is the only point.
That is the only.
You have to share the denial to provide the
No.
legal assistance has
Please.
caused prejudice in a that you have to demonstrate. You want time?
Yes, short accommodation one. Because regulation 6824, as for the regulation of State Bank of Mysore, he can take the assistant of any co-worker, not advocate. Regulation is there. 6824. So may kindly see.
But now inquiry is over and you are dismissed.
Dismissed.
This piece from service, he is retired also.
During the pendency, I have attained the age of 60.
He wants time.
Please. Please, Mr.
Great.
Number 4, Mr. V.R. Datar.
I appear for the third respondent.
Nobody is for the.
In
So
fact,
we are
this
the other-
become infectious in a sense.
In fact, you suddenly notified also, nobody would. Adjourn.
Yes, thank you.
Number 5, urgent. Number 6. Sir R. Krishnamurthy.
I appear for the petitioner, my lord.
Hearing for response. There is a direction issued in the earlier occasion, may not the records of the inquiry proceedings has to be submitted.
May I briefly submit the facts
From
of the case?
retrospective,
My lord,
dismissal is from retrospective.
he sought for retrospective effect.
Dismissal is from
My
back
lord,
date.
retrospective effect. Once he was dismissed,
the-
how can it?
At the first instance, my lord, the order has been passed for dismissal of service. Appeal has been filed before the appellate authority. Order of dismissal has been modified as a compulsory retirement. And the same has been called in question before this honorable court. Annexure E, ink page number 30.
The order is modified to compulsory retirement.
Yes, compulsory
By
retirement
the appellate authority.
From
by
which
the
date?
appellate
From
authority.
which date? Date. Backdated.
No, my lord,
25/5/2005.
I will submit the facts in a chronological order, my lord.
Just a minute. 25/5/2005, the order passed by the appellate authority. That order has been called in question before this honorable court. My lord, Annexure E is the impugned order. Order passed by this honorable court. This honorable court, my lord, allowed the writ petition filed by the petitioner and ordered for re-enquiry. And there is a specific direction issued to the petitioner has been dismissed from service, my lord, on 16/8/2004 after holding enquiry. 16/8/2004. That order has been called in question before the appellate authority, my lord. Appellate authority, my lord, the board of directors modified the punishment of dismissal into compulsory retirement. That is, my lord, on 25/5/2005. The said order has been called in question before this honorable court. Annexure E, my lord, ink page number 30. The operative portion, my lord, the impugned order of the appellate authority dated 25/5/2005 at Annexure C, and the order of the penalty dated 17/8/2004, and the inquiry report are hereby set aside. And the matter is remanded to the inquiry officer to hold the fresh inquiry by providing an opportunity to both the parties in accordance with law, and as expeditiously as possible, and in any event not later than 3 months from the date of the receipt of this order. Thereafter, my lord, the fresh inquiry has been conducted by virtue of in view of the direction issued by this honorable court, and Annexure A has been passed. The order passed by the disciplinary authority. And all the 5 charges has been proved against this petitioner, and the same has been confirmed by the appellate authority by Annexure B. While disciplinary authority, my lord, while passing the orders, my lord, it has given a retrospective effect. Ink page
So you are running some fair price shop,
That is the corporation, my lord, running the, my lord, he is, my lord, the
employee.
employed in the fair price shop. The, my lord, the shop belongs to the corporation, Food and Civil Supplies Corporation. So far as, my lord, the he is claiming the monetary benefits, my lord, after the matter has been remitted before this honorable court in the writ petition. Service benefits, my lord, by the time, my lord, it is already settled.
So nothing on record about compulsory retirement.
Please, my lord.
About the order of compulsory retirement, there is nothing on record. You said that the appellate authority has reduced the punishment.
At the first instance,
Where is that but on record? Neither in your statement of objections nor in his memorandum of petition. It
I
is
will-
stated.
then I will file my detailed statement of
to
objections,
file.
please. Please, kindly grant short
You
accommodation.
retired him from which date?
He is
2004 or prospective?
subsequently,
Then
Kindly give me 5 minutes time, I will make the submissions. my lord.
where is that order of compulsory retirement?
first instance.
Passed by the appellate authority in departmental appeal. Where is that order?
That order is not submitted.
Not
along-
not on record,
But that,
neither by.
that order has been annulled, my lord, by this honorable court. That order of compulsory retirement has been annulled by this honorable court in the petition.
Another matter.
Annulled.
No. He is saying that your punishment is reduced from dismissal to compulsory retirement.
Yes, my lord.
Now, where is that order? Where is the government? Where is the detail?
That order is not submitted along with this petition
I will
because,
furnish
my
along
lord,
with my statement.
the
of
reason is, my
objections.
lord, the dismissal order and the compulsory retirement
But
order
the
were
respondent
questioned in this.
stated that the order of punishment passed against the petitioner came to be reduced in the departmental inquiry and came to be substituted by order of compulsory retirement. However, nothing of the kind is reflected on the record. The necessary details may be produced on the record before the next date.
Number 7, Mr. Vijay Kumar.
Respond number 3 minutes. Respond number 3 minutes. And for respond number 3. Weeks time we will continue.
Week's time.
Yes, please.
Right, sir. And for the petitioner, matter may be called next week because Lord, it's a matter of selection and appointment to the post of work officers. That has taken place in 2015. But I'm not aware the position of the petitioners.
This time it may become infractious.
That's I'll secure instructions.
2014.
Appointment to the post of
Work officers and
Work
first division
officer.
assistants in the.
work of officer.
Yes, ma'am.
So tenure is what?
It's a regular recruitment. Not, it is not with regard to tenure.
Might not be.
That's what, I'll secure instructions with regard to that notes, whether
The
the.
selections are over and appointments are done. Even subsequent thereto, there are notifications.
When I am not aware, my lords, what is the position of the petitioners? It's the reason, my lords, I may be called next week, will.
14,
2015 itself was, counseling was done.
It was really not survived, but
Maybe not. Leave it to Lord.
Number 8.
Lord, I appear for the petitioner in this matter. This matter relates to Lord's denial of including the petitioner into the salary grant, under the grant in aid. Salary grant, Lord. This is the third round of litigation, Lord, the petitioner is before this honorable court. Lords, now the petitioner is already retired from service. Lords, her claim has been rejected by way of endorsement, Lord, stating that there is no provision for including second non-teaching employee into the salary grant. That is the subsequent rules, Lord, which came into effect in 2000, in the year 2000. Lords, the petitioner, Lords, is appointed as clerk cum librarian in the year 1985, 1/6/1985, and she attained the superannuation in the month of May 2015. Lords, she had worked for more than 30 years, Lords, in the said post. Lords, the appointment of the petitioner was approved in the year 1991 itself. As on that date, Lord, as per the existing rules, Lord. The 2000 rules, Lords, may not be applicable to the present case, Lord, the petitioner, which came into subsequently, Lords, and it has no bearing on the retrospectivity. It cannot be affected, Lord. And her appointment, Lords, is approved in the year 1991 itself. Lord, including her name, Lord, into the salary grant, Lord, was rejected on the ground that Lord, her appointment is not approved. Lords, I have produced a copy of the approval of the appointment, Lords, at Annexure B. Annexure B, Lord, at page 21 is the proposal. Lord, Annexure A, page 15, Lord. Page 15, I have produced a translated version of the same, Lord, at page 19, Annexure A. Since the claim of the petitioner was not considered, Lord, this, the petitioner approached this honorable court in writ petition number 10831 of 2010, seeking of writ of mandamus, Lords, to include her name in the list of salary grant, Lord. This honorable court pleased to dispose of the writ petition on 1/4/2010, directing the respondent authorities to consider the claim of the petitioner within a period of 3 months. Since there was no response, Lords, the petitioner approached once again this honorable court by way of filing contempt. Lords, then, Lord, they issued an endorsement on 26/4/2011. That was subject matter before this honorable court in 40505 of 2011. That also came to be disposed on 26/4/2011 to make representation for approval of our appointment with retrospective effect. Lords, there's no question of, Lord's, appointment which was approved in the year 1991 itself. Lord, they hold that, Lord, my appointment itself is not approved. I've produced a copy of the appointment, approval of appointment, Lord, page 15, Annexure A.
so they are not giving salary grant.
Not included my name into salary grant, my Lord. Subsequently, my Lord, they say that, my Lord, 2 persons cannot be included into salary grant in the cadre of Group C.
You file your statement of work.
Yes, not filed, my Lord.
Not filed.
Not filed. Short issue for consideration is this law. She has been employed by the private school. Lord, while granting aid, Lord, the policy of the state is for non-teaching staff, only one Group C and Group D employees are allowed to be recruited and granting aid will be accorded. As per Lord, the government notification dated 26/11/2014.
The first respondent, my lord, relied on the rules which, my lord, which were not,
The
as
request
on the
of
date of
the,
appointment of the petitioner. My lords, it was not there. My lords, they applied the rules. My lords, Karnataka Education Institution Recruitment and Terms and Conditions, etc. Rules 1999. These rules came into effect from 2002, my lord, 2000, my lord, 2000. Lord, my appointment is approved in the year 1991 itself, Lord. They cannot make applicability of these rules, Lord, wherein, Lord, it cannot be made retrospectively. They cannot say that, Lord, my appointment is not approved. They themselves have approved my appointment.
no, no.
The proposal was forwarded to the
The
authority for
approval of
consideration.
appointment only in respect of Lord. There is a provision under section 89 of Karnataka Education Act, which provides, Lord, whenever in an aided institution, whenever the institution wants to recruit any teaching or non-teaching staff, they have to take approval from the government, which is a non-aided post, in order to ensure that the particular candidate fulfills the qualification criteria. That is exactly for the reason, Lord, in exercising power under section 89, we accorded permission to recruit her as a second, as C grade group employee. There was already one C group employee aided post. There is no provision for providing a second C group employee in a private aided school.
Annexure A is what? Annexure A.
Next year is the approval of the appointment of the petitioner. I have produced a copy of the translated version at page 19, Lord. That is dated 17/8/1991. Third point, Lord, the date of birth of Srimati so-and-so is 10/5/1955. She has been appointed as librarian cum clerk and her appointment has been approved from 1/6/1985, Lord. It is wrongly typed as 1983. 1/6/1985 with pay scale of rupees 490 to 950. This is approved by the higher education director.
Yes, under 89, that is what my submission is. This has been approved. Since she fulfills all the conditions, the private institution are at liberty to appoint her. It is the policy of the state to accord only one C group and one D group teaching staff to the private institution.
Annexure J, page 44 may kindly be seen, my lords. In the earlier round of litigation, my lord, the petitioner had approached this honorable court. And this honorable court is pleased to grant, pleased to dispose of the writ petition, my lord, with the observation, my lord. Page 44.
Consider it in accordance with law, my lord. Twice we have rejected.
Since they have not considered, my lord, the petitioner was forced to approach once again before this honorable court by way of filing contempt.
Why you are not including the name in the list?
Lord?
Why you are not paying this grant?
Because, my lord, as per the policy of the state, we accord, my lord, aid in a particular private institution to a specified post. In a private institution, my lord, we grant aid to one C group employee, one D group employee. They cannot appoint 10 C group employee and seek permission of the state to pay a grant in aid.
He is an excess staff.
Excess,
Excess, then your
excess than the
Not for
permissible.
the, that is not the point, my lord, that the rules were made applicable, which are, my lord,
but page
came in the force.
page 98. This is what denial.
Yes, my lord.
Denial by government of Karnataka.
Annexure X is the impugned order, my lord, page 99. That is page number 100. Translated version is at page number 100.
Well, that you would like to wait for the counter, or this can be disposed of by giving
Okay,
direction?
very well. If they want to file any objections to this, let them file all their objections if they want.
In this writ petition filed in the year 2015, some of the objections are yet to be filed. Also, looking to the age of the petition, the reply cum objections will be filed by the respondent within 2 weeks. Subordinate government, Advocate Mr. assures the court that the reply will be filed within the aforesaid time. Stand out to 16th April.
Very well, right. Great.
Or no date. No date. No, you can't give the special bench. Adjourn after 2.
Very well.
Number 9, Mr. S. Anil Kumar.
Petitioner counsel, my lord, prays for a short accommodation, my lord.
Number 10, Mr. K. Puggoda.
For the petition.
Sir, covered by judgment of this one.
The matter is covered by judgments of the Honorable Court. The first judgment precisely, Manoj, which is RF Uday versus State and others, Manoj. Manoj, the issue involved here, Manoj, is the challenge to is Annexure V, Manoj, where entrustment by the state government to the Lokayukta.
Lord, this is directly on the point, Lord. It's a reported judgment of this honorable court. Yes.
Part of my compilation at serial number 6.
ಇದರಲ್ಲಿ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಇದ್ನ judgment. This favors them.
So it is covered
Please, Manoj. That
Against-
judgment,
against you,
no, in my favor.
in
Manoj.
your favor.
Please, I am an employee of the board, Malaj. The entrustment is made by the state government, who is not my disciplinary authority, Malaj. The entrustment should be done to the Honorable Lokayukta by the disciplinary authority, who's the board. I'm an employee of the board. So the government has stepped into the shoes of the disciplinary authority, Malaj. That question has been answered by the Honorable Division Bench and subsequent judgments.
So what is impugned here? What is the challenge?
Annexure V, please. Order of entrustment. Annexure V
Next will be,
at page 115,
yeah, page
115.
150. B is page 16/6/2009.
17/6/2015.
One, three. So ending hour of departmental inquiry to the Lokayukta.
Please, Manoj.
So what order is passed?
That's at 116, if I may read. Government order dated so and so. For the reasons mentioned in the preamble, in regard to the allegations against Sri so and so Assistant Executive Engineer, Bangalore Water Supply Board, that he has, without issuing at least 3 prior notices as required under section 53(1)(c) of the Bangalore Water Supply and Sewage Board Act 1964, and violating the rules, affected the disconnection of water, and departmental inquiry thereto is entrusted/ordered to be to the Upalokayukta under Rule 14A of the CCA rules. So this entrustment is under challenge. Manoj.
So here what is to be read in this?
No, my submission not is that this judgment is not applicable to the facts and circumstances of the case. My lord. The one which I have produced in WP number 2581 of 2016 is directly on the point. In this case, the employee is from BWSSB, my lord. And the government has entrusted the inquiry to the local. And this honorable court held that, my lord, it is proper. Which I have produced. What is it?
Yeah, this one.
SV Ramesh. 2581 of 2000.
Let me go through it, not
Yes.
local. Let it come.
So one more important factor. This judgment which my lord and for the petitioner relies on RF Vedavath is in relation to employees of KRIDL, Karnataka Rural Infrastructure Development Limited. But KRIDL, as on the date of filing of this petition, had not adopted the CCA rules. In this statement, KRIDL, statement which my lord fertilized.
Lords, even if the CCA is adopted, my lords, the fact remains that this is a board. The CCA is, my lords, published by the government, which the board adopts, my lords. It's an instrumentality of the state. It's not the state precisely. So it can't be my appointing authority, my lords.
Next Friday.
That in the very judgment in para 28 and 29.
If I happen to sit single again on next Friday, I'll.
Please, sir.
Yes.
Here for the petitioner, my lords.
I pray for a
Here,
short
the-
accommodation, Lord.
My lords, this is a 2015 matter. And we
Polar
are,
25th.
we are now in 24. My lords, this prayer is for reservation of 3% of posts. The prayer is at page 13, my lords, in the posts for the members in the district consumer fora for persons with disabilities. And of course, another prayer is, if my lords would consider that, to consider the petitioner. In any event, at least the first prayer is extremely important because the district fora all across the state are appointing members. And as per the Persons with Disabilities Act, in all posts, now the old act said 3%, now it says 4% for persons with disabilities.
You file your counter.
Yes, please.
Very good.
May I just make one submission, my lords? This is a 2015 matter, 9 years, government has not filed its counter.
He said his counter.
Yes, but let
Right.
some date be put. Finally, it may be that the petitioner himself he may not get any relief, but at least in the larger picture, we should get
I shall file within.
Whenever. you-
in 10 days, my lord, some relief, some date.
Date 4th April,
My lords may keep it on 3rd, my lords.
3rd.
3rd, great. Great.
My lords, appear for the petition. Petition has become infectious. Petition has turned infectious. Infectious. Learned Advocate Mr. Deepak J for the petitioner states that the present petition has become infectious. In view of the statement made by learned advocate, the petition is disposed of as infectious, as having become infectious. Before that, by filing this petition, in the beginning, the petitioner prayed to direct the respondents to allow the petitioner to appear in the interviews on 28/7/15 for verification of his documents and for oral interview on 29/7/15 for the post of assistant professor in veterinary biochemistry, and further allowed the petitioner to appear with scrutiny committee. Then when the petition comes up for consideration today, learned will stated that.
Number 13, SB Mukanapa.
Petition in this case, after hearing some time, this honorable court has directed to us. Any settlement is chances there. My learned counsel,
Lord, in this case, I appear for the contesting respondents 1 and 2. Lord, as a matter of fact, on the last occasion when the matter was heard for some time, there was a proposal for settlement. Lord, we are at it, Lord, some time may be granted to us so that we can explore the possibility. A week's time may be granted so that we can.
So allegation of defalcation of money,
Yes.
temporary or what?
Our contention is that it was a temporary.
You were a cashier in the bank.
Yes, yes.
Why wouldn't I? Now, so many years have passed.
now there is no question of reinstatement because
Therefore only we are asking.
he had put in more than 30 years of service. Moreover, the inquiry also in the effective in inquiry. So I am also is contesting, challenging the fairness of the domestic inquiry also.
You are for bank.
Yes. So I,
Able to convert the punishment into
my Lord, I have,
compulsory.
in fact, I have advised my clients, but they need some more time, my Lord, so that something can be done, will happen, my Lord.
When you retired?
In 2013,
13.
Yes, 31/1/2013, on that day is attained the age of superannuation.
See that now the much water has flown.
My Lord, certainly we will do something.
If it converted into compulsory retirement, and
That is what, my Lord, that is what I.
prospectively you will get the
Yes, ma'am.
benefits.
Terminal benefits you would get. That is what,
Prospective.
yes, my Lord.
You agree for prospective, prospective terminal benefit,
Yes,
not for the interest. If the bank agrees.
that is what I advised him, them. my Lord.
Find out.
Yes.
Number 14,
Lord, in this case,
Subramania Bhatt.
I appear for the petition. Lord, the matter pertains to promotion. But there are large number of annexures which are in Kannada. So
And I've filed my objections, my lord. That may kindly be put up, my objections are not put up. Objection.
Number 15, Sachin BS.
That's appearing for petition, my lords, asked for the matter, my lords, senior is in total 2 minutes.
You have to supply translation if you have to proceed.
Yes, ma'am.
Many documents are in Kannada, impugned one also, impugned also. Will adjourn.
Yes, my lords.
serial number 11, my lordship. Serial number 11, can you put the first or second, my lordship? Date given, my lord. Third is out of station.
So which date do you want?
My lordship, I'm the petitioner that case.
3rd April it is kept. 3rd April.
Second, my lordship.
2nd April. Convey to the other side.
Second, my lordship.